Hey y'all, what is going on? What is going on? It's your girl, Melba Pearson, Melba for Miami, Melba for Justice, also known as the resident legal diva. And it's time for another Mondays with Melba. I hope everyone had a wonderful weekend. This past weekend was Easter weekend. It was also Passover. And I believe that many of the major religions have had a holiday this weekend, including our Muslim friends, as well as some other religions. So, however you chose to celebrate, whatever you chose to celebrate, I hope it was wonderful and filled with love and family and friends and all that good stuff. All right. So, the topic of today, I'm getting back to my roots because if y'all remember, many times when I started off with Mondays with Melba, it was mostly me talking about different legal issues, different cases that were working their way through the system, or different bills that were coming up. I wanted to make sure to have a balance of guests with y'all so that way you're meeting and learning more about different candidates, learning more about different offices, because to me, I fully believe that a well-informed voter is the best voter you can have, right? So you understand what you're voting for and you understand how to use your power wisely. So thought that was really important to continue to center that. So next week, we're going to have Representative Fentress Driscoll, who's going to be on the show talking about this legislative session here in Florida. But in preparation for that, wanted to talk about a couple things. So first off, last legislative session, so in 2021, there was a bill that was under the number of Senate Bill 90. And that was a bill that really stripped away voting rights in Florida. And some folks might be like, well, how did that happen? Okay, so some of the key provisions were, and one of the worst ones was number one, instead of your vote by mail registration lasting for 2 presidential cycles. So meaning, let's say you register to vote by mail in 2020, that covers you for the 2020 presidential election and the 2024 presidential election. Then in 2028, you would have to decide, okay, do I want to continue to vote by mail or not? You'd have to make an affirmative decision in 2028 to continue to receive your vote by mail ballot at home, right? That's how it was before. Now, this bill that became law, Senate Bill 90, which is now law, shortened that window. So you have to register to vote by mail every 2 years. And so the idea being that the more often that people have to register to vote by mail, the less likely they are to do it. They'll forget that a deadline is coming, and then that forces them to have to go out and actually vote in person or not vote at all. Because you think about these different provisions, it's all about making voting more accessible. It's about making voting easier, right? We want everyone to vote. But unfortunately, those in power feel differently and think that by removing some of the folks that are voting now, they can have their way and they can continue to hold the seats that they have and push forward legislation that's not beneficial to all Floridians. So, you think about the things like, listen, most folks work regular blue collar jobs, whatever the case may be, service jobs. You don't get that time off from work to go vote. Or if you get your hour lunch hour and you decide to go vote in person, well, if the line is too long and you have to be back at work, you're not going to stay in line. So that's how it ends up impacting voting rights, because less people have access to the ballot box. So that shrinking of the time frame was really problematic. Some of the other features of the bill that I'm sure folks have heard a lot about is number one, you're not allowed to give out food or beverage to anybody who's waiting in line to vote. So think about the fact that our primaries are in the summer, in the heat of August in Florida, right? Like it's 90 degrees in the shade when it comes to August in Florida. What do you mean that groups can't just hand people out water so that they stand in line, right? They also had a provision where if you left your place in line, even if you asked the person in front of you or behind you to hold your spot, the minute you get off that line, that's it. Like you have to go back all the way to the end of the line. Again, to discourage people from going to the bathroom or anything like that. Again, just inhumane, horrible things. Some other things that they were really cracking down in the Senate Bill 90 that became law was third parties who register people to vote. So you think about the NAACP does voter drives. You think about the League of Women Voters does voter registration drives, not telling people what party to register for, just being like, you need to register to vote, right? So they started to really crack down on third party organizations, telling them that, creating a whole new list of protocols for them to be able to register people to vote. They have to share all these different disclosures, again, which is very burdensome, especially when you think about most of these organizations. There could even be churches. They don't necessarily have this big infrastructure and website to be able to comply with all of these things. So they were just really trying to find different ways to make voting much more burdensome for people in Florida. So what ended up happening is that a group of organizations got together, your usual suspects, your League of Women Voters, ACLU, Southern Poverty Law Center, folks like that, as well as impacted voters, got together and sued the state of Florida saying, listen, this is not going to work. This is unconstitutional. This is, again, stripping away people's access to the ballot box, which is unconstitutional, and this can't stand. So Judge Walker, who is a federal judge in Northern Florida, which is where the lawsuit was filed, heard the case and gave his ruling. And his ruling, y'all, was fire. When I tell you fire, fire. Here are some of the things that he did. First off, so this all went down on March 31st, and he struck down a whole bunch of different aspects to the Senate Bill 90. So first off, he started, and he wrote a 288-page decision. I mean, that's long, right? Like, as a lawyer, I can tell you, like, that is a long, drafting, because most judges will give their order in a couple of pages, whatever. He went all out, and that shows you just the level of problems that this bill posed. So first off, here's some of the things he reversed. He reversed the quote unquote line warming ban, which is basically if you are in line, ask somebody to hold your spot for you, and then you would come back to your spot. This bill outlawed that. He struck that down. He also determined that handing out food, water, or any other items, napkins, that sort of thing, is not a problem. Like, you should be able to do that. So he struck down the part of the bill that prohibited groups from giving out water, fans, different items to people who are standing in line, right? Listen, still at the end of the day, there is a whole requirement that if you're handing out partisan material, so in other words, you're handing out a leaflet that's supporting a particular candidate, you can't go to the line where people are waiting to vote and hand it out. You have to be a certain distance away from the polling place in order to hand out those types of items. That has always been the law, and that continues to be the law. But what Senate Bill 90 did is that it said you can't give people water, even though they're sitting out here dying, sweating, trying to be able to vote. So the judge struck that part down, said that it was unconstitutional, and well, dumb, right? Also, there was another part of it that talks about ejection of nonpartisan election protection workers from the no solicitation zone. So like I was saying a moment ago, there's a certain zone where if you want to hand out materials in support of a candidate, you have to stay behind this line. You cannot bother people while they're online to vote. The difference is people that engage in election protection, which basically means you're observing the process. You're making sure that, number one, the machines are working, right? People aren't complaining that the machines aren't working. If somebody speaks English as a second language, that they're able to have someone translate the ballot for them. You can bring your own translator, like a loved one, family member, whatever, or you can ask for accommodations once you get to the polling place. You are supposed to get that by law, right? So election protection workers are usually there, again, not associated with any party. They may be associated with an organization. So for instance, the ACLU has done a lot of, election protection, Common Cause, League of Women Voters. They will go and again, observe just to make sure that people are able to vote and that there's no issues. This new bill would have required that anybody who is engaging in election protection cannot be where people are voting. which means you can't see what's going on and you can't see whether or not proper election law is being followed. That's the purpose of these monitors, right? They do it as a volunteer thing just to make sure that everybody has access. So the judge struck down the part of the law that forbid people who are nonpartisan, so not attached to any party, election protection folks, they are now again permitted to go through and be in the polling place to again make sure that voting is going according to the way it's supposed to by law. Also, it reversed the whole Dropbox accessibility thing. So, as you know, when you vote by mail, you can drop your ballot off at a Dropbox at a polling place, right? So it's usually you get your vote by mail ballot. You can either mail it off, right, if you have enough time, because of course you have to remember with the mail being a little slow, right? You have to keep in mind, okay, your ballot has to be received on election day. And so if you're thinking, hey, I just finished filling it out and election day is in a week, is that enough time for my ballot to make it in a mail? You may want to drop it off in person. The two ways you could drop it off in person is either one, go to the supervisor of elections office, so for whatever county that you're in, or number two, you can go to a Dropbox that would be at any early voting location, right? So this law stripped away the ability to go to early voting places and just drop it off to only when the polling place was open. So again, think of it this way. You work late, right? And so you get off work, it's 11 p.m., and you want to drop off your ballot. How it is right now that you could go to, before Senate Bill 90 came into play, you could just go to the supervisor of elections office, even though it was like 11 o'clock midnight, drop it off. The office is closed, whatever, but it's locked, much like you would a mailbox, right? You can drop off your mail in any mailbox at any time of the day and night. They were trying to have the same kind of system for your vote by mail ballot. Well, Senate Bill 90 came into play and said the only time you can drop off your vote by mail ballot is at a polling place during early voting hours. And again, that's problematic because not everybody works on the same shift, right? So Judge Walker was like, and he knocked that down as well. He struck down the requirement of organizations that do voter registration, do that in like a nonpartisan manner, struck down the requirement that they have to put some kind of disclaimer on their website. As I talked about a little bit earlier, that becomes very problematic, especially if you're not an organization with a huge capacity. You're just a bunch of volunteers who are doing this because you want to make sure more people have access to the ballot box, right? So Judge Walker took away that requirement, which was awesome. So what other awesome things did he do? Basically, he just really went in on the third-party voter registration drives, saying that, folks just really need to be able to process and get these applications out to where they need to be, to the supervisors of elections, et cetera, in a timely manner. And all of these things that the Senate Bill 90 did was making it harder for organizations to connect people with their ability to vote. So that was, this is all massive, right? So what does that mean in the long run? So while this is an amazing victory, the governor has made it very clear that him and his Attorney General, Ashley Moody, intend to appeal this decision. So what happens is that right now it was in the district court, which was Judge Walker. It's now going to go to the Federal Court of Appeals. So our Federal Court of Appeals here is a bit more conservative. So I don't know that this is going to be a long-term victory for us. I hate to say it. Now, the question is going to be whether or not the appeal gets filed and heard in an expedited manner so that there's a resolution before the primaries come this August. Is all going to depend on the docket or basically load that the appeals court has and how important they deem this to be. But it's entirely possible that they could expedite the appeal from the governor and that they may end up ruling against those of us who want to see more access to the ballot box, rule against us in time for the August primary. So again, got to stay tuned on that. I'm going to keep an eye on it, but I'm going to relish this victory for the time being. And of course, encourage all organizations who are doing, voter registration drives to like go ham. Now is the time, right? Because we don't know what's going to happen in 3-4 months, and the ability to do certain things may not be in effect in a few months. So we got to strike now while the iron is hot. So that's one big case that is working its way through the system. The second one is around the Don't Say Gay law. And I hate that the fact that it's a law, but it is what it is. So as many of you have heard, Florida, awash in sunshine and bigotry at times, which is very disturbing and disgusting, passed a law that was purportedly around parental freedom to be able to have more of a say in how their child is educated. And one of the huge components of that is that you can't, have any discussion or education around sexual orientation or anything like that between the grades of K through 5 or as age appropriate. So here's where the devil's in the details, right? Number one, this was a bill that was a solution looking for a problem, because teachers in the state of Florida are not teaching sex ed in those grades, right? Like that, they're just not doing it. That's not an issue. That's not something that's been happening. But the way that they wrote this law, it's so overbroad that like schools are freaking out because they have no clue how to comply with this. And if they're not in compliance, they could have their funding stripped. And that, of course, is huge, because we already know that our schools are under pressure. Our teachers are already woefully underpaid, even though they just got a raise last session. That still doesn't raise them to a competitive level, right? So that's an issue. So you have all of that going on, and then schools freaking out and wanting to avoid any drama would then go all out and basically throw the baby out with the bathwater. So they're making sure to have no discussion of anything, and trying to like remove different types of books and make sure there's no reference to LGBTQ issues or anything like that, which again is problematic for a number of reasons. So if you think about the fact that kids often don't have a loving home to be able to deal with these issues, right? So if you're working through your gender identity, your sexual identity, you may not necessarily have a supportive home to have these discussions with. Your family might be super conservative and not want to discuss it. Your family may not be present, right? Just from the standpoint of your family's working too much or whatever the case may be, because rents are so damn high, realistically speaking. And, folks gotta sometimes hold down multiple jobs in order to pay the bills. As a result, you're not always home to be able to talk through some of these issues with your kid. Or maybe, again, your family is just, not loving and supportive and abusive. Kids come to school with all kinds of circumstances. So to have that ability to go to a counselor and talk through these issues, or, have a teacher say something that's affirming in class, is really important for that child's mental health and for that child's ability to thrive and flourish and not feel like I'm not seen, right? So this was what was really problematic about the bill. And let me just read the law for you specifically so you understand exactly what I'm referring to. It says, classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. So what that basically means is that parents can now sue jurisdictions, so sue school districts over teaching about sexual orientation and things like that. And, now the whole developmentally appropriate thing, when does that end, right? I mean, they specified K through 3, but as developmentally appropriate could be all the way to high school, right? Because then there's no expiration date on what's developmentally appropriate. We don't know what that means. It's not specified. That's why whenever you write a law, you have to be very specific about the timeframes, about parameters, all of those things, because if it's too vague, if it's too broad, it becomes unconstitutional because people don't know how to comply. So that's why schools are freaking out and just like removing books and just like, doing things willy-nilly, because there's no standard set forth of this is how you comply. And this is how, if you do this, this, and this action would be problematic. This would be something that would run afoul of the law. It's sort of like you're going to do it and wait and see and like kind of hold your cross your fingers and cover your eyes and hope that it's not a problem, right? So here are some potential issues that can come from it. So if you're a teacher and you're married to somebody of the same sex and you have your photo of a wedding photo of you and your spouse on the desk, is that going to run afoul of this bill? And you may say, oh, Melba, you're being silly. Well, no. If a kid in your class, a student, sees that photo and asks, oh, you're married, you're a man and you're married to a man, why is that? Or is that your cousin? Like, like a simple innocuous question. Now the teacher's in a position of like, how far can I go in answering this question before I run afoul of this bill? What is going to happen if I just say, hey, I'm married to my spouse who's of the same sex, and another student goes home and says, oh my God, Mom, guess what I heard in school today? My teacher's gay. And now the parent gets their, underwear in a bunch, freaking out like, oh my God, you're trying to indoctrinate my child, and then runs and sues the school district. Then what? And it just all started from an innocuous comment of, yes, that's my spouse. So, that's one way of looking at it. Or if a child comes to school and talks about their parents, that their parents are in a same-sex marriage, is that no longer permissible? Does the teacher now have to shut it down and say, no, you can't talk about your family? Because that could somehow be perceived as trying to, quote unquote, indoctrinate kids into the LGBTQ lifestyle. And I'm quoting their words. This is not my words at all, right? Because at the end of the day, listen, being gay is not a choice. I'm gonna go out there. I'm gonna just say it. And if you want to unfollow me because of it, it is what it is. But from my experience interacting with people from the LGBTQ community, and hearing their journeys and everything else, looking at my own personal journey just through life and all of that, listen, life is short. You got to be with who you love and who you want to be with. You don't need to follow some societal standard that is outdated, right? Love is love, and love should always win. So that's that. So I'm just going to come out with that, plain and simple. But at the end of the day, LGBTQ people are not looking to, increase the numbers. Let's go out recruiting on Friday night. Like it's not like that. Nobody's like that, right? Like it's just so ridiculous. And all of this is just based on tropes and misconceptions and bigotry, really. So as a result of this bill becoming a law and being so overbroad that schools have no clue how to comply, and students are in danger of feeling erased, and parents are freaking out like, can I send my child to school even though they identify as LGBTQ, or discussing our family out of pride at school? If we can't do that, what are we doing here? Like, where is our freedom? Where is our democracy? So a group came together to file a lawsuit, again, challenging the constitutionality of this bill. And so that includes our friends at Equality Florida. Big shout out to Equality Florida for really standing in the paint on this one, and several other groups. They're basically challenging this and saying that this is unconstitutional. It's overbroad. It's arbitrary and discriminatory because, again, if you're not setting out clear protocols, then the way it's enforced becomes arbitrary. It means that how the laws in Miami-Dade County might be different than enforced in Osceola County or in Pasco County, right? Or Polk. Everybody's going to have their own standards because there isn't one set defined protocols around this bill. So those are part of the grounds that they're challenging this bill on, that and the fact that it's an attack on free speech, because now everybody's going to have to be afraid of what they're going to say because they don't want to run afoul of this bill. So the lawsuit has been filed in federal court. I anticipate that this is going to get a lot of attention over the course of the next few months, as well it should. Most of these lawsuits tend to take a while. So for instance, in the case that I was just talking about with regards to SB 90, the voting rights bill, that legislation passed at the end of last session last year. So we're talking about the summertime, and now we're getting a ruling, and it's almost like, 8 months, almost to a year later. So I believe that we will see some resolution come from this case probably next year. And then moving forward, of course, there'll be an appeal, and we'll go back and forth. So this is going to be a little bit of a longer plan or a longer journey because of the fact that, there's going to be a lot of depositions, meaning that there's investigation that has to be done and all of that. But again, you've got, parents, you've got teachers, you've got students all involved in this who are all saying this bill is problematic. This law is problematic in the way that it's laid out and in the way that it's impossible for people to be able to comply. So that's the story behind those two. I will keep you posted as more details become available. And if possible, I'll try to bring on folks who are involved in this litigation to be able to, shed more light. And, I'm going to pause there for now. So y'all, thank you so much as always for tuning in. Hit me up in the comments. If you've got questions, definitely drop those in the comments as well. And I'm happy to come back through and answer them. And of course, if you have other topics that you want to hear me cover, other guests that you want me to bring on, issues that you're curious about, hit me up. Slide into my messenger because my DMs are open, or just drop something in the comments as well. Because again, I want to make sure that this is something that is useful for all of you, to make sure that we're answering questions that you may not necessarily be able to have answered in other formats. So with that, take good care. Hope to see y'all next week for Fentress Driscoll, our representative out of the Tampa area, to talk about last legislative session and what might be on deck for 2022, 2023. All right, take good care, y'all. Bye.